Well, hello, everybody. Welcome. Thank you for joining us this afternoon. So excited to have you here. Hi, Jillian. Hi, Zeno. Merwat. Hi there. Merwit. I always pronounce that wrong. I'm so sorry. Anyway, thank you all for being here today. We are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there's my phone number. There's my email address. I would love to talk with you and help you in any way that I can. And email is usually best. It's funny because just as I was hopping on to this call, I had an email from an attorney, and it's interesting because it's like we do the same thing. We email back and forth and decide when's a good time to talk, right? So we'll end up doing that. But anyway, just wanted to thank you for being here. I'm very appreciative of your time, and I have a lot to tell you about, not just the material that we're going to be discussing today. I got some credentials, highlighted kind of the legal stuff, but as most of you know, I don't give legal advice. I'm not a practicing attorney, but I'm, God knows, I'm way deep in the field, so it's kind of a scary thing, but it's okay. Got well over 40 years in real estate. Um, some of the stuff we're going to talk about today, I do teach in my law class at UCSD, but obviously I spent a lot more time on it there than we're going to have time to do today, and in a different manner. So that being said, we're going to be talking about stuff that's going to appear to be legal. I am not a practicing attorney. I have no intentions whatsoever. I think they work way harder than we do, and we frequently make more money than they do. So okay, so I do a lot of trial work, obviously, as an expert witness, and so I'm as a court certified expert witness. And you all recall that the Department of Real Estate says you may not call yourself an expert unless it's in a title. So, like a certified distressed property expert, or in my case, a court certified expert witness, things like that. So, my specialties are standard of care. So, did the agent do what they were supposed to do? Um, and agents' duties of inspection and disclosure, market conditions in San Diego County. Conversation day not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Very, very important point. If your broker tells you to do something, remember your broker is responsible for you. And while you may not always know the answer or the reason behind it, it's you need to be able to trust the broker that you're working with. That being said, our talk today is intended to be interactive. Please ask questions, offer input by utilizing the Q&A button. We just learned in the very beginning, way before the COVID thing came around, we learned that the Zoom program, you can go hot mic sometimes, and then you mute after that. But unfortunately, the program will decide whenever it wants to unmute you, and sometimes at the most awkward of situations. So we don't tend to do hot mic at the moment. So I'm going to change that, by the way, and I probably should bring this up now. But the association is working away from the current dynamics of how we were doing how they were doing education. I'm going to be moving in a direction where I will be doing more podcasts. And I think that the podcast will allow me to be more interactive. We'll probably not be using the Zoom platform. I know that I have done quite a few talks for the Department of Real Estate, and I know that they don't care for the platform because of the security issues that are involved in it, mostly on the speaker's end. So the security issues are on my end, and in their case, when they're doing such a thing, the security issues are on their end. So we're probably going to be doing more Google Meet kind of things. I can get more people in there. We've got enhanced versions, and where'd you go, Zeno? I thought I saw your hand go up. I hope you're doing well. Thank you so much for being here. So anyway, we're going to be doing more of that. We'll be doing less of the 2 hour long things. That way I'll be able to post podcasts that talk specifically about specific things, like the transfer disclosure statement we'll be talking about generally today, but the transfer disclosure statement, I'll probably do a podcast just on the first paragraph, or in my case, paragraph number C on page 2 in section 2, and that's the part where we talk about the very, yes or no, is the seller aware of any of the following things. And so I find that I've yet to receive one that was filled out properly. but those are the kinds of things that we'll be able to do by doing them in capsule, in shorter get-togethers. So I'm already working on it. Our first speaker is going to be the prosecutor for the city of Huntington Beach. Wants to talk about a real estate transaction that did not go so well there. And I've got law firms lined up, and real estate specific law firms lined up. So we should have a lot of fun. It sounds like it's going to be great. I've got a microphone now that I've never, I only saw these in the days of radio. If you can see that microphone, this is the microphone that we'll be using in our podcast. So it's kind of an exciting thing for me. I feel like I'm finally getting into the 90s, as they say. So stay tuned. If you're getting my newsletter, you'll have access to what we're doing at the time. We have quite a following on the newsletter, and so, but you'll have access to what the current things, whatever those things are going to be. So that's just the way that is. And so I do look forward to hearing from you always. As you know, I want to help. So Master My Farm, we did this morning. We had a ball with that. That was a lot of fun. I will upload that onto the YouTube website so that you have access to that on the current version of that. I think I just keep getting, more and more ideas when it comes to that. That is one of those webinars that would lend itself to breaking it into sections rather than being 2 hours where I'm literally compressing everything as much as I can to get it all in there. So, and we'll have a similar situation here now with the disclosures we're going to talk about. So we're going to be doing disclosures, statutory versus contractual. There's quite a distinction between the two, and quite a few things can happen in the course of a real estate transaction with those disclosures. So I want to thank you for joining. Disclosures, statutory or contractual, which one is it going to be, and why is that important? So today's conversation is going to focus on disclosures in the residential real estate sales transaction. And we're going to distinguish between the disclosures required of the seller, but also those of the real estate agent. So, we've got two different grounds that we're on. And we as real estate agents, we tend to be afraid of essentially two groups of people. One of them is the lawyers, of course, right? And then the other one is the Department of Real Estate. And I'm going to tell you, if you know generally what is expected of you, you will be much, much better shape than you would have if you're just kind of freewheeling it here. Okay, so it's kind of important to know what we're doing. And so I'm obviously preaching to the choir because the people that are here today want to know how to do all of this properly. So statutory. So let's talk about a statutory disclosure. Why are they required? So in California, there is no caveat emptor. Now, caveat emptor, you remember, stands for buyer beware. So there is no buyer beware in California, and I can tell you that there's a long list of cases. Some of which you'll be familiar with and others not. In California, it is definitely caveat vendor, which is, you don't have to get really good at Latin to know what this is all about. Just know that means let the seller beware. And so, it's kind of the opposite. But then again, we do things differently in California than they do in other parts of the country. And I've always said that the laws move from west to east. They come up with some of the craziest cases in California. We get to be the harbor of that. And then they slowly make their way across the country. So, I'm a broker. I have a broker's license in Virginia. I teach in Virginia, live classes, things like that in Virginia, and they are 20 years behind California, but it's coming there, right? I always tell them, I'm the advanced team for the lawyers. So, for what's coming to Virginia is already going on in California. So where and what are required. And so East and West Coast have different approaches to the issue. So in California, everything must be disclosed. In Virginia, it's best not to say anything, literally the opposite. I did a real estate transaction in California with an agent who had been licensed in Virginia and was now doing, and I don't know for good or for bad, her very first transaction in California was with me. And again, I'm a DPOR certified instructor in Virginia, as well as I do classes in California. I'm an instructor here as well. And so her very first transaction coming from Virginia was with me in a transaction. She says, I'd never seen so many disclosures ever. And I said, well, you're from Virginia. And so, you really didn't have any disclosures. There really weren't anything. You had some documents prepared by the state of Virginia, but in California, it's, listen, we're constantly building, a defense wall up to help the real estate community, as well as the buyers and sellers that are out there. So, I was chair last year of a position at the California Association of Realtors. I was chair of the Realtor Risk Management and Consumer Protection Forum. And so I remember consumer protection was always so important to me. And obviously, by protecting the consumer, I protect the realtor, and all that. Those are good things. But here I was, I went in to say hello to the commissioner who was following my meeting, after lunch, following my meeting. And so I went in and I told him in front of all the other commissioners, and I said, we're in the same business. And he said, how's that? And I said, well, I says, I'm Realtor Risk Management and Consumer Protection, and you're all about consumer protection. And so we're really in the same line of work. And I want you to know that as a real estate agent, you're not there to kind of, pillage and blunder and do things like that. You're there to help people, hopefully, and you just try not to get into harm's way. We're going to talk a little bit about that today. And he agreed with me. So why are they required? So the seller, why are there disclosures required of the seller? To assure that those with the most knowledge of the property share that information with the buyer, right? So the seller, who's better to know about the property than the seller? Okay. And so we're going to talk a little bit about, the seller's never lived in the place or anything like that. That is not a rule. Okay. It does not matter. California law is pretty clear about the disclosure, the transfer disclosure statement, et cetera. So the standard of care for the seller is knew or should have known. So that's kind of a big bucket. Okay. For the agent, it's going to assure that the real estate professional does their due diligence in the real estate transaction. And we're going to talk about that as well. So the licensee has an obligation to provide those forms necessary for their client to complete their transaction. And I'm going to differentiate between the customer and the client. So the customer is someone that you have casual conversations with. And by the way, the law is going to be changing here fairly soon on that buyer representation agreement that I've talked about for the last couple of, probably 10, 15, 20 years now, where you're pretty much going to have something in writing. And in Virginia, where I teach, they made it a law as of July of last year, 2022, that you must have a buyer representation agreement with the buyer, right? So you must have one, or you may not be compensated. And the sad truth of it is, it's really not about the compensation. It's really about, do you really have a client? Do you have a contractual relationship with the person that you're working with? And just much like you have with the seller, you must have one with the buyer. And that's going to be coming, I suspect that by January, it's going to be a law in California. So, maybe I'm wrong, maybe it's July, but it's coming. Okay. So when you have a client, right, that's somebody you have a written relationship with. Okay. All right. So by virtue of their license, the real estate licensee is authorized to explain the standard form. And this comes up quite frequently when we're involved in a real estate transaction. I can tell you that we frequently get people sending us documents to sign, affiliated business disclosures, things like that. And they ask the client to sign, our client to sign it. And our response is almost always going to be this: by virtue of my license, I am authorized to explain the standard form. And the standard form in our industry, at least, is that form that is created by the California Association of Realtors in most cases, right? It as zip forms or glide or things like that. So, I can explain the standard form, but when I get a form from someone that is created by a different brokerage, we got one today, affiliated business disclosure from a brokerage, and I looked at it and I said to the client, I said, I really can't tell you whether or not you should sign this form. It's not a standard form. I don't have a license to give you legal advice, and explaining a form other than a standard form is going to be legal advice. So my position always, whenever I get a form such as that, is I tell my client, I can't advise you one way or another. You need to speak with counsel about that. And we have actually a form, interestingly enough, and I want to show you this because it's kind of a cool form. I'm going to take us over here to these are my this is my cheat sheet. You all can see this. This is my statutory versus contractual disclosures, and we have a form now called the non-standard forms advisory. And so I'm going to type that in right there. Where did it go? Oh, shoot, we're going to give it a different name. Oh, here we go. Use of non-standard forms advisory. So I'm going to want to add this into the transaction. And so a lot of people are going to be going, oh my God, I didn't know we had that. So here it is. Let's open that up. Okay. I have folders on all this. So if you want any of this, just let me know. Here is my non-standard use of non-standard forms advisory. And so what I was just telling you a second ago, this is a really good explanation. Transaction documents, advantages of the standard forms, non-standard forms, and in that document that I got today, there was an attempt in the document to have our buyer waive certain rights. And so, I know what I'm looking at, but I can't say that to the client. I'm probably better tasked to doing that than most anybody. But I can't tell my client that it's you're going to waive your rights, because that would be legal advice, right? And I import that to you in that you just generally would have to accept that that's going to be the case. Okay, so broker's advice, this is what it is. Because non-standard forms may contain terms and conditions that differ from standard forms, and your real estate licensee is obligated to present to you all documents received by another party, you are advised of the fact that they may contain terms and conditions, again, written by the lawyers, that differ from non-standard forms and sometimes complete conflict with it, right? It may contain terms which are not in your best interest or may negatively impact your legal, contractual, and financial rights and obligations. And then finally, your real estate licensee cannot advise you on the legal and practical implications of non-standard forms. Now, I've been giving this speech for well over 20 years, and my hat is off to the California Association of Realtors. We just came up with this form back in June of last year. Okay, so again, it reinforces what I've been telling you already about which forms I can explain to people and which forms I cannot explain to people. So let me go back in here and let me see, where am I? New share, back to my stuff here. So again, by virtue of my license, I'm authorized to explain the standard forms. Everybody good with that? Other than that, what else do I have to do as an agent? So as an agent, a reasonably competent and diligent visual inspection and to disclose to a prospective purchaser. Now, this is from the original statute, to disclose to a prospective purchaser any facts that affect the value or desirability of the property that such an investigation would reveal. Now, listen, I'm the first one to tell you, we have a term at CAR called the QCREA, and the QCREA is the Qualified California Real Estate Attorney. So qualified, someone who is a real estate attorney. California, a California attorney. I always tell the story of the client that said, well, I talked to my lawyer and my lawyer said X. And I said, wow, I've been teaching lawyers this stuff for 25 years now. And so I've never heard of that. Where is your attorney? And well, they're in Illinois. And so when I say to them, I say, well, did you tell your attorney that in Illinois that you were asking them legal advice on a California situation? And they said, well, no, I didn't quite say that. I said, I know you didn't say that because they could be disbarred for that. And so, so just like you and I are limited to giving advice in the state of California, non-legal advice in the state of California, an attorney from Illinois is barred from discussing California law. It's just completely outside of their jurisdiction, separate rules, separate laws, and they could literally lose their bar for that. Okay, but when I talk to a real estate attorney, this language I just read to you is the language that they can, it just comes right out, it spit right out, because it's what we do. I find that in most of my cases where somebody has hired an attorney. Remember, the standard of care for an attorney is that they have to either be an expert or be able to become one fairly quickly. And so I do a lot of transactions where, I may be, working with an attorney that most of the attorneys I work with are real estate attorneys in California. But sometimes I'll find that I'll be in a case that is not involving a qualified California real estate attorney. So I think that's really good advice. Okay. So, but this language, the value or desirability of the property, we're going to talk about this. So Easton, why are they required? So the Easton case, I love the Easton case. I mean, Easton case just threw us on our head, right? So the Easton case was the precursor to California Civil Code 2079. So let's talk about that here for a second. And again, please ask questions. That's what I'm here to discuss with you today. But I'm going to take us to Easton first. And so I found the annotated version. I actually took the case itself as written by the California Association of Realtors, so the pertinent parts of it. And I highlighted the stuff that is really important to you and I. And so this was a lawsuit that involved a property back in the 70s. There was a transaction that occurred. Believe it or not, yes, you and I, 50 years later, are still dealing with these cases. Okay, so and maybe rightfully so. I can't give you an opinion on that, right? So in 1984, which is this document number right there, it went to the California Appellate Court. Okay, the third district. All right, so in other words, there was a lower court holding, and that holding, we'll see in a second how that went. There was a lower court holding, and then I'm looking at the attorney in the case, and the attorney in the case is someone that I know very well, even today. In fact, I just saw him last week, and God love him, he's getting older. So, I hope he's around for a while, but very bright man. But in 1984, that lower case was appealed. And so we call it the Easton case because that's the first word in it. So it was Easton v. Strasburger. And so the Eastons were people that bought a property from the Strasburgers. And so let's take a look at some of that. Notice here, Court of Appeal, First Appellate District, Division 2, and again, California Appellate Third, the third. And so this is where it's published. And this one was published. And published means that now it's the law. Okay, so here are the judges. Here's the opinion. So the real estate company appeals from a judgment. In other words, they lost at the lower court. Now, by the way, when you're in the lower court, it's expensive. To lose, it's still expensive, right? But then you appeal and you go up to the next level. You just took expensive and multiplied it 10 times, if not more. Okay, so you got a lot of money in this at this point. Okay, so in this case, the lower court ruled in favor of the buyer, and we'll see why in a second here. We're going to talk about this just a little bit. So first of all, the respondent, that's going to be the Eastons, purchased the property for roughly $170,000. I know most of you are driving cars that cost that much today. From the Strasburgers in May of 76. Escrow closed in July. Appellant was the listing broker. So the appellant is the one who's appealing this case. So they were the seller's broker. Okay, so there was a massive earth movement. Again, you can see why I highlighted this because it's a pretty long document. There was a massive earth movement in 77 or 78. Now, this purchase occurred in 76. Okay, so in 77, 78, there's this big soil failure. Portions of the property were on fill, had not been properly engineered and compacted, caused the foundation of the house to settle, et cetera, et cetera, et cetera. After the slide, here's all this damage. Cost to repair, roughly $213,000, with, if you do the math, $43,000 more than what they paid for the property. Okay, all right. So agents conducted several inspections of the property. They were aware of red flags. Remember, at this point, there was no avid, there was no obligation, at least in the minds of the real estate companies, to tell anybody anything, right? Which is very similar to Virginia today. I see nothing, I hear nothing, that kind of thing. But they were aware of some red flags. All right, and they did not request soil stability and did not inform the respondent that there were potential soils problems. Okay, so the seller, the agents had done these things, and the seller had not told the agents this, and I'm not sure if it's in this part. The agents didn't request the soil stability or things like that. Okay, everybody good with that? So during the time that the Strasburgers owned it, there was a minor slide in 1973, and then a major slide in 1975. Okay, Strasburgers did not tell the agents anything about the slides or the correction action that they had taken, right? However, it gets better. So the buyer purchased without being aware of any of these problems, and then obviously brought suit. So the jury returned a special verdict finding that all named defendants had been negligent, right? So negligent in the transaction, and assessed damages that were, again, more than the amount of the cost of the home. So we move forward from here. There's some contributory negligence issues, things like that, but we're going to move forward. And so Now we get down into the discussion. Let me see if they go into lots of court cases, which God, I hope this was the one that I did all the work on. It looks like a lot of it is missing. There we go. So in summary, with the case, the duty of the real estate broker. Now this is the holding at the appellate level, representing the seller. So the seller's broker to disclose facts. And again, they talk about Cooper Lynch, and again, this is the Cooper Lynch was the original case that started all this. Includes the affirmative duty to conduct a reasonably competent and diligent inspection of the residential property listed for sale. Where have you heard that before? How many times you can hear it in your sleep? How many times I have said that, right? Reasonably competent, diligent. Why? It's in the TDS. Okay. All right. Disclose to prospective purchasers all facts materially affecting the value or desirability of the property that such an investigation would reveal. I just quoted that for you 2 minutes ago. Okay. All right. So real important stuff. This was in the holding of the court. Okay. A seller's broker in a residential real estate transaction is under a duty to disclose facts material affecting the value or desirability of the property, which through reasonable diligence should be known to them. Now, the question is, arguably, did they notice anything that they should have disclosed? Okay. And again, this is out, perhaps we'll talk about the buyer's contribution to this in a minute. So, because such agents are expected to make use of their superior knowledge and skills, right? So, I don't know. I remember when I got my real estate license, I don't remember there being any classes on construction defects or, on things like that. Interesting. But I have superior knowledge somehow, which is the reason they're engaged. And because the agents were or should have been alerted, and this is the real case, to the signs of soil problems earlier described, the jury was well within the bounds of reason when it concluded that a reasonably diligent, competent inspection of the property would have included something more than a casual visual inspection and a general inquiry of the owner. So in other words, we're going to be going ahead in leaps and bounds. Okay. So give me 1 second here. I just have to got to get on an airplane tomorrow. I'm heading to Oakland, and so I need to make sure I'm going to be on that flight. Okay. All right. That being said, let's fast forward here. Again, I will send you this case if you want the case. I will send it to you. So appellant's agents, okay, the appellant was, of course, the real estate company, were aware of the fill on the property and the erosion, and that erosion and settlement problems are frequently associated with such soil. And so uneven floor, the use of netting to repair a previous slide. I'm going to stop doing that. That's not going to work. Things like that. So you see something. I remember walking through a house in Del Mar, in Sandy Point, which is the north end on the water side. You've got the inlet and everything from the San Diego River. And so I remember walking on the second floor, and I remember that, I felt that the floor would not survive a manometer test, which is essentially putting a marble on the ground and watching it go all over the place in the house, right? So it's obvious to you as a real estate agent. So I always tell agents, pretend like as if your client has never seen the property. Okay. I don't care if they've seen it or not. Treat them as if they've never seen it. You have an obligation to disclose things that were apparent to you, even though I know you don't have any, you haven't had any education in manometer readings, or certainly any education in half the stuff I've been involved with in court. But you are expected to at least use your head. So anyway, the petition for a hearing by the Supreme Court was denied. Oh, that really bad. So in other words, the brokerage lost at the lower court, then they lose at the appellate court, and then the Supreme Court says, we're not going to talk about it. We're not going to hear the case. And so therefore it becomes the law of the land. Okay. And that's why this is so very important. And it's not like these people were spending a lot of money on this. All right. So a couple little side notes, despite the absence of privity of contract, and they call privy of contract, which means, the buyer and the seller are the ones under contract. Right. The real estate agent is clearly under a duty to exercise reasonable care to protect those persons whom the agent is attempting to induce into entering a real estate transaction for the purpose of earning a commission. So now, again, this was the holding in 1984. A lot has happened since that time that we don't really need to go into at this point. But this became the law of the land. And as I said a second ago, This became the precursor to Civil Code 2079, and I'm going to show you that one in just a second as well. So in the typical residential transaction, the buyer in particular may be intentionally or inadvertently led under such circumstances to believe the broker will represent his best interest where he is aware the broker has a listing agreement with the seller. Since the broker's commission is generally paid as a percentage of the sales price, the broker's interest is more closely identified with that of the seller than of the buyer. Oh, starting to sound like that buyer representation agreement making more sense, right? Where the buyer is unappreciative of the potentially divided loyalty of the broker, right? So the buyer's broker now may be lulled into relying on the broker to his significant detriment. Misplaced reliance by the buyer can extend beyond the issue of price to questions regarding quality of title, condition of premises, proration, et cetera, et cetera, et cetera. Is everybody okay with that? I'm starting to see hints of what we're going to deal with now, 50 years later, 40 years later, with the buyer representation agreement and where that's coming from right now. So effectively unrepresented because of the problems of dual agency. Purchaser of commercial real estate is likely to be more experienced and sophisticated, et cetera, et cetera. I put that in there just because I wanted you to know that they do differentiate between residential and a commercial real estate transaction. So this is why I tell people, stay within your field of expertise. If you're a residential broker, then you should, continue to do activities as a residential broker. If you're going to take yourself into the commercial side of things, then you might want to consider, getting educated on that. So that's the Easton case. All right. So again, licensee has a duty to disclose to a buyer material defects known to the broker but unknown to and unobservable by the buyer. If the broker fails to disclose known material facts, he or she is liable for fraudulent concealment or for negligent misrepresentation. Okay. All right. And negligent misrepresentation essentially means that you said something or you asserted something that you didn't necessarily know the facts about, whether it was true or not, but you said it. And so, that'll be negligence. Okay. So then we come across the field case. And the field case, oh, fascinating case, came out of Otay Mesa, came out of our, San Diego. Fascinating case, imposes greater fiduciary duties on the buyer's agent. Okay, that was the whole point behind that case. So let's take a look at that just really quick. So I'm going to go back over here to my slide and I'm going to talk about the field case. And so again, partial publication. Now here's the thing: the field case was really a statute of limitations case, and whether or not the action against the brokers was barred by the 2-year 2079 statute of limitations preventing recovery by the buyer. Okay, so again, without getting into the legal stuff, because I don't really want to do that, it was partially certified. The problem was that the case itself had nothing to do with what ultimately it ended up being. I remember talking to an attorney, Neil Kalin, who's I think just a brilliant real estate attorney, and I remember him saying it was in the dicta, which is just the language that the judge wrote. They were really not kind to the real estate agent here in California, and as a result, everybody picked it up as if it was the law. And essentially became the law. So this is Robert Field versus Century 21 Cloud and Finesse. Here's the case on this one. So it's a little bit shorter for us. I've toned it down quite a bit. So the 2-year statute of limitations established by Civil Code 2079 doesn't apply for claims for a breach of fiduciary duty brought against the brokers by purchasers whom they exclusively represented. So Century 21, which was the company, doesn't claim the evidence is insufficient, but challenges the trial court's failures to find the action was time barred. So against this, again, the 2-year statute of limitations. So here was their conclusion at the appellate level: the fiduciary duty of a broker who contracts to exclusively represent a purchaser of real property to investigate for its client is independent of the separate obligation imposed on a seller's broker to conduct a reasonable visual inspection of the marketed property for a buyer's protection, as announced in Easton. Okay, all right. So we had a rural residence out in the middle of nowhere at the time. Of course, it's completely surrounded by homes now. The brokerage failure to inspect related title documents determined the scope of an easement. In other words, the broker made a representation as to how big the easement was, how much it affected the subject property. The defendants falsely represented that it had an easement only for the use of the driveway, although in fact the easement prevented them from exclusively using a major portion of their property. Okay, remember that, folks. When you're doing a real estate transaction, remember to check the preliminary title report, have the title company blow up the map, plot and color code all of the easements. Okay, we had a transaction just recently where we bought a house that the previous buyer didn't buy because there was an easement running down the middle of the property, and that buyer wanted to put a swimming pool in. And so they discovered during the transaction that there was that easement, so they chose not to buy the property. Well, we didn't care about the swimming pool, so we ended up buying the property. So just remember that you've got to know about what these things say. Now, there was some interesting little twists to this case. So it turns out the easement was more extensive. And included the right to spill water. Okay, this is Otay Water District. This is that big water tank that you see on the road. You know, when you drive, it's up on top of the hill, and it says that they had a right to spill water onto the Fields property, which is the buyer, including some area occupied by the residents. Now, how would you like to know that, right? So the acreage was not as represented; it was much smaller. The buyer's agent was aware it existed, but never verified the extent of the easement or the represented the acreage of the property, nor did she advise the Fields to do so. There's the big problem, right? So that's why you see your forms today. You know, there's so many admonitions to the buyer. You know, do your own investigation. Don't rely on the agent's investigation or inspection, because the agents don't have the same duty you have. Okay, so anyway. The additions to the house violated setback requirements. There were a lot of problems in this transaction. So the brokerage did not recommend inspection of the septic system for code compliance or alert the buyers of signs of obvious physical defects. Ooh, sounds like Easton again. So the agent did not inspect the preliminary title report in a timely manner. She didn't even receive it from the title company until after escrow had closed. So my caveat to you is, do not let the transaction, talk to the buyer and the seller, have them talk to their attorney, because you can't tell them not to close the transaction, but tell them it's probably in their best interest to review the prelim. Remember, you get the prelim, you got 5 days, right? According to contract, okay? Let me see. So anything else? I'll jump through this. Did not recall asking anybody about the easement. Did not explain the Fields. Could have had the title company come out and mark the easement. Did not recall verifying the acreage information presented in the MLS. Did not recall checking the prelim for acreage information. So what should you do? Consult with the title officer, explain and plot the easement, what I just told you, failing to investigate the status of permits for the room addition or advise the Fields to do so. Okay, so here's our discussion. 2079. Now, where do you know 2079 from? Well, you know that because that is my agency disclosure form. So do you all see this? So this is my California Civil Code 2079 right here. So this is part of it. This is a snapshot. This is a photo taken of part of the Civil Code. Okay, so again, 2079, big law. I'm loving it. It's good stuff. 2079 requires sellers, real estate brokers, and their cooperating brokers, buyer broker, to conduct a reasonably competent, diligent visual inspection of property right out of Easton and disclose all material facts, et cetera. Establishes a statute of limitations for breaches of those duties to 2 years. Okay, that's essentially what that means. So it was enacted to codify the holding of Easton. And in Easton, the court recognized that case law imposed a duty on sellers brokers to disclose material facts actually known to the broker. Okay, so knowledge that they should have known. So statutorily, 2079 statutorily limits the duty of inspection to a visual inspection. Okay, so and then a bunch of cases happened after that. The statutory scheme expressly states that a selling broker has no obligation to purchasers to investigate public records or permits pertaining to title use of the property. But 2079 does not include or involve an inspection of areas that are reasonably and normally inaccessible. So you see all this language when you look at your TDS and today your Avid. Okay, so scrolling forward to the really relevant parts. So I'm going to go past that. Fiduciary duty. Now we're going to talk about the fiduciary duty: highest good faith and undivided service and loyalty. In other words, put the buyer's position above yours. In other words, they are more important. You represent them above any interest you might have in the transaction. Okay, so fact that a broker must learn and the advice of counsel required of the broker depend on the facts of each transaction, et cetera, et cetera. And here it is: the broker must place himself in the position of the principal and ask himself the type of information required for the principal to make a well-informed decision. So in other words, they should have been looking out for the buyer, in which case they did not. The court held that they did not do that. Okay, all right. So again, Miller and Starr is quoted frequently in the legal channels. Let's see. principal may rely on his fiduciary's investigation. In this case, it was represented to the buyer that the agent had done this research. So no duty to investigate independently of his agent when the agent makes the assertion that the agent makes. Okay, that's what that's all about. VAGI is just jury instructions. And so let's see, disposition, and there you go. You've got your case. That's the field case. I mean, and unfortunately for us, it didn't go well, right? So that being said, let's go ahead. I'm going to take us back over here now to our PowerPoint. Let me see who's my grouping here. Okay. All right. So imposes a greater fiduciary duties on the selling, the buyer's agent. Okay. All right. So standard of care. Why are they required, right? A real estate licensee must use the degree of care. This is the standard of care that I testify to. Real estate licensee must use the standard of the degree of care that a reasonably prudent real estate licensee would exercise, and is measured by the degree of knowledge through education, experience, and examination required to obtain a real estate license. So again, I'm held to the standard of care that a licensee, a reasonable licensee, would be held to. And so, think back about all those classes that you took when you got your real estate license. That you're held to that standard. Now, again, there's no construction defects, things like that you were educated on. I have probably a bigger problem than most would have because I have a law degree. So I'm going to be held to a higher standard. But that's why I don't give legal advice. I don't, impart any of that information when I'm doing a real estate transaction. Okay, so Wayne Bell, former real estate commissioner, this is a quote from him in one of his bulletins, and I think I have that. I can give you that bulletin as well if you're interested in it. Where did I have it? It was in here, and I liked him. He was a really good writer. He was also an attorney, by the way, so I don't have it right in this packet, but I'll send you all this stuff if it's something that interests you. So, okay, that being said, back to our PowerPoint so we can get out of here by midnight. Some even have the potential of costing you your license. So what's the difference? So let's talk about my statutory disclosures finally, right? People are like, wow, we're finally going to get to that. So what are my statutory disclosures? So they contain rescission rights. All right. So statutory disclosure means a disclosure that is required by law. So, when I say Civil Code 1102.3, I'm talking about the transfer disclosure statement. It's a statutory disclosure. Okay. So they contain rights that what we call rescission rights. They're different than a contractual disclosure, which merely contains a cancellation right. Rescission right means put the parties back in the position that they were in prior to creation of the contract. Okay. In other words, make it all go away. So, when you start telling the buyer that they're going to lose their deposit, or you tell the seller that they're going to get the deposit, well, you better be hoping nothing happens to impact a rescission right where the parties get put back before contract, in which case the buyer is probably going to get their deposit back. So never make that, never opine that what's going to happen to a deposit, because you know what, this will turn it on its head. Okay. So it puts them back in the position that they were in prior to creation of the contract. Okay. So let's use an example, disclosure regarding real estate agency relationship. This is going to be California Civil Code 2079. And so I just want to show you the form really quick. We're not going to be able to do everything form by form. Where am I here? Nope, that's not what I wanted. That's my use of non-standard forms. So actually, literally, I have a whole template created for all the standard forms because I know that they're going to be updated, for me automatically when we update the forms. So here's my agency disclosure, and I don't need all that. Here's my agency disclosure. And so as some of you remember, we actually updated this in October of 18. That was when we changed the language. Seller's agent, used to be the listing agent. The buyer's agent used to be the selling agent. And it confused a lot of people. And so we decided that it was time to rewrite the statute. And we did. We got all of the attorneys together, and they created all this stuff. And they said, we're gonna do this in plain English. And I always get a kick because I often use the term, we're gonna do it in the Queen's English. And so of course my broker Linda looked it up and said, it's not the Queen's English. And I said, I know, but everybody understands what I'm talking about. We need to write it so people understand it. So remember that in order to be enforceable, the contract has to be written in plain English. It has to be written in, language that everybody can understand. Okay. So now my listing agent is the seller's agent, which makes sense. And my selling agent is now the buyer's agent, which makes sense. And this document, if you've never read this, and I know people that I've talked to have been in the business for 40 years and have never read the agency disclosure, and I was tasked to review it for legal veracity, grammar, spelling, and all that kind of stuff. I found one mistake on the entire document. And this is about almost 30 years ago. Okay, so it's just a photo of the actual statute. Okay, so why is that important? Because the statute requires that I disclose the concept of agency, and that's what this form does. It discloses the concept of agency. That's why we put it as the very first form in your template, the disclosure regarding real estate agency relationship, right? So it is the concept of agency, and so the Department of Real Estate says you must disclose that concept of agency prior to committing any conduct that constitutes agency. So clearly, before you start showing property, clearly before you write an offer, clearly before you take a listing. Even Wayne Bell said, we think you should be having it signed at your open house. What a great thing to have signed, right? Because there's no contract created, right? It's a disclosure, but there's no contract created when you disclose the concept of agency. Now, remember, when you write your offer, at that point, now you know whether or not you're going to be single agency or dual agency. Okay, we all want to be dual agency. Here we go, agent representing both the seller and the buyer. Okay, but whenever we're going to be a dual agent, our standard is going to triple, not double. I think triple. Okay, so we want to be really careful. We have attorneys in Linda's office who practice real estate with us, and they won't be dual agents. They tend to represent sellers, but they won't. A buyer calls them up and says, I want you to write an offer for me on the property. They're like, nope, not doing it, right? Because in the legal field, we don't understand this concept of dual agency. How can you not know something from one party to another that advances one party's interest? And so they're always going to say, I'm the seller's agent. So we make it work in Linda's office, by essentially what we do in Virginia, which is called designated agency, is still dual agency, right? But some of us understand that. Some of us don't have the wall up. Some of us have the ability to understand the concept. Remember, we confirm. The law says we must disclose the concept of agency, but then we must confirm agency at the time of contract. Because when you write the buyer representation agreement, when you write the listing agreement with the seller, you don't know if you're going to end up in a dual agency situation or not. Okay, and that's part of why we do it. Why we tend to do it that way. So let me pull up. I'm going to pull up the agency disclosure. Oops, I'm back in the same one again. I'm sorry about that. Let me see here. Where's my? Here we go. So nope, that's 12 years of college down the tubes. It is not letting me out of that. So let's get out of that. No. New share, it goes there. I'm just trying to find my form. Okay, so I had my disclosure, and then I have my confirmation of agency. So I have this whenever the name in the RPA is misspelled. So in our case, when somebody writes an offer on one of our properties, we are the listing agent, the seller's agent, but our name is truncated in the MLS to make it fit, right? Because it's Burke Real Estate Consultants, Inc. It's a long name. Now, some of you work with companies that have that same issue. So now I must go back in and fix those errors, and that's what I do my confirmation of real estate agency relationship form to do. Does that make sense? I must disclose the concept of agency, but then I must also confirm agency at that later time. Okay, all right. For some reason, I don't know how I'm going to get back to my other form, but okay, that's my agency disclosure. The first form your client should ever sign. I think that's really clear. Before they do anything else, you must disclose agency. I'm aware of a case in San Diego where the Department of Real Estate took a $66,000 commission away from a brokerage because agency disclosure hadn't been done until the day before closing. The transaction coordinator discovered it, and the DRE said that's just way too late. You should have done that before you wrote the offer in the first place. And so $66,000. I mean, I'm surprised, that they could have taken their license for that. So okay, so that you always have them sign it, you always give them a copy. So that's my first one. And now I've already told you about the confirmation of real estate agency relationship, also Civil Code 2079.13, only if not done properly on page 2 of the RPA, right? Okay, that was the whole point behind that. Then I have my EPA, my lead paint disclosure. One of my favorite subjects. Let me see here. Okay, I found it. All right. So my lead paint disclosure. Here's my agency. By the way, I do all forms up just in case I lose my internet connection. So here's my lead paint. So this is my LPD. It used to be the FLD, right? The federal lead disclosure. Now it's a lead paint disclosure. And so make sure you're using the current forms, folks. All right. And so as I go down through here, this is a statutory. This is actually an EPA regulation. It has a full force and effect of law, right? And there have been some changes recently to this, what we call the paint renovation, the renovation rule, okay? And so you see that down here just above the paragraph number 1, and it requires the contractors and maintenance professionals working in pre-78 housing, childcare facilities, schools with lead-based paint be certified, right, et cetera, et cetera, et cetera. You displace more than 6 square feet of lead paint in a room or more than 20 square feet on the exterior, it needs to be done by an agency that's trained in how to do that, okay? So failure to make this disclosure used to be a simple $10,000 per offense. Now today it's way much more than that. I don't even want to go into that. So again, this is going to become now U.S. Code 42. It's 42 U.S. Code 4852D. And so again, another of my my happy statutory disclosures, okay? All right, so here they are. I wrote them all out for you in case you want this. And again, I'll send you a copy of all this, but we have a form for that. It's the LPD form, okay? Up to $200,000 per offense. Imagine selling a 64-unit apartment complex and you don't give the disclosures to any of the tenants. That would not be a good thing. Violators may face civil and or criminal penalties. And I can tell you that I made the mistake of going to YouTube and looking up the what effect that lead-based paint can have on children, for example, because they tend to be the ones that are injured with it. It's a sweet tasting, the paint is sweet tasting, and kids tend to chew on it, and it does permanent, irreversible brain damage to the child. And I tell you, it's if you're weak of heart, I wouldn't be going to watch that video. It is just heartbreaking. So anyway, be aware there are a lot of reasons for why this is a big deal. Okay, anything pre-78. Okay, pre-78. Now that doesn't say that we didn't have lead paint after pre-78, but maybe a commercial application or something like that. So don't assume that all paint is, you may want to have your client have a test. Okay, that kind of thing. Okay, so triple damages, otherwise known as treble damages. Hi, Jillian. Treble damages. Jillian, question? Some people think I may be one of those children. So Jillian, if you have a question, can you put it in the Q&A box for me? I'm happy to answer it. Okay. Treble damages in a private civil suit. Sellers must provide homeowners or home buyers a 10-day period to conduct a paint inspection or risk assessment. And again, it's in the form. Parties may mutually agree, unfortunately, in writing to lengthen or shorten the time period for that inspection. Okay, and that's the scary part, is that they can waive the inspection opportunity. What if the house is rebuilt in 16 but still registered on tax roll as a 1958 build? That's an excellent question. So what harm does it come for making the disclosure? And that's going to be my question. And so let's take a look at the form just really fast. I'm going to go back to it just really quick. And here's why. There's not much to this, right? This is the disclosure that's required. Now, we always have the environmental hazards disclosure that are required regardless of when the property is built. So, and that includes in rental properties, okay? So you can see up here, it's pre-78 housing sales, leases, rentals, but in all transactions we have to give them the environmental hazards report. That's and the lead-based federal lead paint disclosures and things like that. In fact, let's take a look at that really quick. And so I'm sorry to jump around on you like this, but this is important stuff. So we're going to go back over here. We're going to say none. We're going to get back to the transaction that we're in. And I'm going to take you over here where, actually, I'm going to take you over here to, this is called your library. This is where all the forms reside. I'm going to click on, which one am I? I'm going to click on this up here. I'm going to go to my EPUBs. So under EPUBs, I've got my residential environmental hazards, my protect your family from lead. That's required by law, whether it was built pre-78 or not. So these 6 things, most of you are doing a natural hazard disclosure, and that natural hazard disclosure, depending on the company that you're using, that this is why it's so very important that you use a company that knows what they're doing. They must make these. They usually make these disclosures in that report. So we work with a company that for sure does that. That for sure has all of these disclosures already in the report. That puts moves the liability in another direction for us. That works out really well. But I don't have that same protection when I don't have that natural hazard disclosure company. And not all of them do this. And so then we end up having to do additional disclosures later. And those are the surprise stuff that we still must do by law. So there are going to be some big changes I'm going to show you in a minute about what's going to happen in the fire hardening and defensible space area. And we're going to talk about what's coming up starting the first of the year. But for us here, this stuff that I'm showing you right here under California EPUBs is required in all real estate transactions, 1 through 6, required in all real estate transactions. Obviously earthquake pre-1960, lead paint. We're going to have to disclose the lead-based paint issues anyway, but we have the additional disclosure when we have a pre-built 1978 home. So in your question, let me pull that back up again. The house is rebuilt in 2016. I ask you whether or not there's any harm in doing the lead-based paint disclosure, because your question is, it was built in 1958. Okay, so the home was built in 1958. So if it was, clearly you have to make the disclosure. But you remodeled it in 2016. Did you remodel it sufficient enough to escape that it's now a new home? If it's rebuilt, so you didn't use the word remodel. If you'd used the word remodel, I'd have been a little happier with it. But okay, did you eliminate all of lead-based paint? Oh, by the way, remember the renovation rule? Okay, you displaced all that stuff. It needed to be done. Did you have that done? So if you didn't have it done by the required agency, somebody with that certification, then you need to be making the disclosure again for sure anyway. So Jillian, to answer your question, I would probably make the disclosure anyway. And because what is it? It's a form, right? And so when I look at the form, and let's take a look at the form again, when I pull the form up, you can see the form, good. When I pull the form up, I see that there's really not a lot of interaction in here other than explanation. But when I get down to paragraph number 1, the sellers or housing providers disclosure, we have no knowledge of lead-based paint. And the answer may be, yes, I have no knowledge. I find frequently, I really want to see this form completed. So in other words, other than the following, I would, if the seller is not aware of anything, then I would say NA, but I see this blank all the time. I never see these filled in. I think this should probably say NA if the seller's not aware, okay? Because it says, other than the following. Well, there isn't anything, so I don't know, okay? We have no reports or records pertaining to lead-based paint and or lead-based paint hazards in the housing other than the following, which previously or as an attachment to this addendum has been provided to the buyer or tenant. I'm probably going to see NA in there as well, but I don't believe in signing below a blank, okay? And so my advice is going to be that the seller completes these 2. And then we get down to here, we see the risk assessment that I spoke about earlier. I'm sorry, let me maximize that screen a little bit for you. And then, after page 1, what is there to do? After page 1, it's all just everybody signing that they understand all these issues and these things that are going on. The buyer understands they've got a 10-day risk assessment period, which they can waive, which, did that box get checked? Did the buyer do the lead-based paint assessment? If not, they probably should be checking that box, okay? All right, so a great opportunity, Jillian, thank you. Gives us an opportunity to analyze the form. I don't see any harm in doing the form if there's a question such as, what was the extent of the remodel? Okay, that's what I did. Good for you. I knew you would. You come to my classes. You're awesome. So yeah, use the form. Listen, better to be safe than sorry. Okay, Zeno, it can be tested with swabs by the appropriate inspector at reasonable expense. That's true too, right? And so, like, why didn't you have it inspected? It's not that expensive. I purchased a home in Del Mar that was built in 1960, and obviously earthquake, but clearly lead paint. It had been painted 100 times over, and I still had it tested. And by the way, I had the ceilings tested. Of course, it came up with asbestos, and so we had to do some stuff in the property. But it's better to know that before I buy the property than to find out later on that the tenant, for example, in this case, had a tenant in it. They were hanging their potted plants from the asbestos ceiling, and every time they screwed the plants into the ceiling, they made the asbestos friable, and it floated around the house, and it's like, oh my God. So those are things that are going to be very, very important. So better to be safe than sorry. Jillian, thank you so much. Zeno, thank you so much. Okay, good. All right, so thank you for bringing that up, because a lot of people, they think, well, it was rebuilt, we did the remodel, and I look at the advertisement that real estate agents do, and I see complete remodel. You don't ever say that. Fully remodeled. What does that look like? What is the definition of a fully remodeled property? Down to the slab. I almost think that a fully remodeled property doesn't even include the slab. In other words, everything got taken away. But there's a difference between a remodel, and there's some statutes that involve how much of a remodel becomes a rebuild, for example. So a remodel can be 10% remodel versus 90% remodel. And again, Del Mar, as an example, has different phases of what constitutes a remodel. If you have to leave one wall up, and then you can call it a complete remodel. Well, that's okay for them. That's not okay for court. So I'm probably going to err on the side of caution on that. So home buyers, and Jillian, good work on that. That was a good call on your part. Homeowners may waive their right to the inspection. So my TDS, I love the TDS. Does anybody know me? I love the TDS. Okay, so we're going to have some exemptions, but I want to show you the form just really quick, because it's one of my favorite forms. And I can tell you that, let me take us to, there we go. So I'm going to get rid of that. Here's my transfer disclosure statement. Make sure you're using the current version of it. And on that note, since I am already in ZipForms product, let's go ahead in there and pull up the standard version. Because once again, I've got templates for all this. So I don't have to worry about whether or not I'm using the current version. Okay, is everybody okay with that? Let's go to my TDS. It's one of my favorites. Okay, I've never seen one filled out properly. I hate saying that because I get called in on these all the time. Look at this date, 6/23. Now I showed you that because this was just amended. Here was the one in my file, 12/21. Okay, so I'm clearly not going to use that one, and I'm going to show you what the changes were that took us to the 6/23 version. Okay, so up here at the top, this property is duplex, triplex, or fourplex. Yes, you've got to do one for all of the units, okay? But what happens if you only do some of the units, okay? Maybe you're not, you're selling the entire thing, but you need to make the disclosures on all, okay? So I rarely ever see this part filled out properly. I've got a case right now where they didn't put in the name of the county, the date. The date is when the seller completes it. Right. But remember, the law changed this past year that says that the TDS that's in effect when the buyer is given it in a real estate transaction, the law that affects the TDS will be the law that was in place when that TDS was given. So if the legislative body changes the TDS in the middle of the transaction after that, then you know that the laws relating to the TDS that the buyer was given at the time that it was given, that's the laws that are going to impact it. So in other words, you don't need to redo the TDS. So in the middle of a real estate transaction, buyer gets a TDS from the seller, it's all signed off on. No need to redo it if the law changes in the middle of your transaction. Okay, we have CAR has a really good Q&A on this paragraph right here. We added the terms forms, no substituted disclosures for this transfer, because people were not completing. The first two weren't applicable in a lot of cases, and I have the Q&A on it. I'll send it to you. It's a good one. So in most real estate transactions, probably the seller is going to check no substituted disclosures, right? But again, every situation is different, okay? And you can't tell them. You can give them it. I always send over the substituted disclosure form, right? But you really can't give them legal advice. You can give them guidance, but not advice, okay? Paragraph section number 2, they need to check the boxes. Where I see most frequently done incorrectly is down here. Are there, to the best of your seller's knowledge, any of the above that are not an operating condition? Yes or no? I will frequently get this back from the seller's agent where this is not completed. Excuse me, where they haven't checked the box. That's going to be called a defective TDS, which the buyer has 2 years from a defective TDS to bring a lawsuit against the seller for the deficiency. Same thing at top of page 2. Are you, seller, aware of any significant defects, malfunctions in any of the following? Yes or no? And again, this is a 3-hour class with the attorneys, but anytime they answer yes to anything, you need to explain it, okay? Let's see here. Paragraph number C, I frequently get it where no is checked all the way down. And, there's just no way that the property can be no to everything. I mean, I'm looking here, CC&Rs or other deed restrictions or obligations. All properties have restrictions on them, right? So I don't know how you can answer no to that. Neighborhood noise problems. My house in Del Mar is on the train tracks, right? So, I've gotten used to it. But I don't know, if I'm there, I'm listing my house with somebody, the agent should be listening for that train, that kind of thing. But I need to be reminded sometimes that there's a train that goes by there. I got the helicopters going by from Miramar to Pendleton, things like that. So I rarely ever see this completed properly. And probably this is going to be a good example of one of our podcasts. I'll probably end up doing a podcast just on paragraph C. Okay, and it's going to probably be half an hour, rather than 2 hours. But obviously, I can't cover, this form in this meeting. We're already over an hour into it. So, down here at the bottom, for those of you that are wondering, every time you hear me say, your smoke detector, your smoke detector, your water heater statements of compliance are now included in paragraph D at the bottom of page 2, so you don't need the separate form, okay? And we just had a transaction, today where the transaction coordinator sent us over these forms. It's like, we don't need to sign the forms because they're in the TDS and the agent is using the current TDS. Okay, all right. And then look at this language here. Based on the above inquiry, as to the condition, based on a reasonably competent, diligent visual inspection, accessible areas of the property. Listen, we learned our lesson with the Easton case. Okay, so here it is. Here's the language. All right, and so remember also that the law says that the TDS is not considered complete until the seller's agent provides their avid to the buyer. We have a transaction right now where we still don't have the avid. Okay, so it's not complete until the avid is provided to the buyer. Okay, all right. What else in here? Watch out for the automatic signatures down here. A lot of our signature platforms, at least for a period of time, we're automatically tagging the seller and the seller's agent's signatures before the buyer's agent completed paragraph number 4. Okay, so make sure you're not having them sign, under a blank. If you remember what I said before, never sign below a blank. Everybody good with that? That's my TDS. That's a very fast go around on the TDS. It's one of my favorite forms. Certainly keeps me busy in trial. Okay, there are going to be some exemptions to the TDS, and so let's take a look at that. I'm going to take us back to the exempt seller disclosure. Here's the problem with the exempt seller disclosure. If I can find it, where have I hidden it in here? Here we go. So here's the problem with the exempt seller disclosure. You do not have the knowledge to determine whether or not a seller is TDS exempt. Right? I don't care how good you think you are. It's going to require an attorney. It's going to require a court, somebody that says that the seller is exempt. Okay, so the problem is we've had quite a few transactions, and most of which I'm going to be kicking up to the Department of Real Estate, where the agent insisted that the seller was TDS exempt, and I don't know if they are. And I know that they're going to come back. DRE is going to come back and ask me to do a report on it, but we can't make that decision, and so remember that if they are TDS exempt, and there are very few cases where they are, that just means they don't have to do it on the form. Okay, so they don't have to use the TDS form, but they still must disclose what they knew or should have known about the property. They can't say, I don't have to tell you anything, I'm exempt. No, you're exempt from using the form. Everybody okay with that? Remember, this is a disclosure class, okay? So use by sellers who are exempt from completing a TDS, or for any seller who does not provide an SPQ, any seller. Okay, so why? Because in the SPQ, we see this paragraph number 3 is in your SPQ. All right, the exempt seller, what the death on the property. So the TDS doesn't contain any reference to Civil Code 1710, which is the law that requires the disclosure of death on the property in California. So there's nothing on the TDS anyway. But if somebody died, you still must make the disclosure. If somebody died on the property, you still must make the disclosure. Now, there's an argument that says that people don't actually die on the property because unless they're completely dismembered, but because you really can't, the EMTs are not authorized to pronounce death. Interesting situation. So technically, death doesn't occur until they either get to the hospital or to the coroner's office. But again, that's also a legal conversation I'm going to recommend that you not have. Okay. All right. Sadly, I've had people repeat it back to me, and I'm like, oh, no, that's not what I said. Okay. So you're not qualified to do that. They need to talk to an attorney. Okay, here it is right here. May wish to, brokers qualified to advise on real estate transactions. If the seller or buyer desire legal advice, they need to talk to an attorney. Okay, so here's my exempt seller disclosure. Here's all the stuff not in the TDS that still must be disclosed by law. Statutory disclosures. Everybody follow me there? This is my ESD. Okay, and oh, by the way, the reason they say, why do you didn't provide the SPQ? Why do we then require the ESD? Let me pull up my SPQ really quick. Here it is. I got my SPQ. So again, I like doing this in live format because then I show you the most current version of the form. But here's my SPQ, and gee, what do you know? I get down into here, paragraph number 6, statutorily or contractually required or related, and here's my disclosures: death of the property in 3 years, right? So here's all my disclosures again that were just included in the ESD, and so again, the SPQ covers those disclosures. Again, the standard of care, standard of practice in California, I would be very, very certain to make sure that this is included in the transaction. So in all the transactions where I've had the seller's broker claim that the seller is TDS exempt, I have yet to have one of them send me that proof. And so I've got 4, 5, 6, 7, 8 emails asking for proof and getting denied at every turn. So I'm sorry, I'm not going to defend you in that case. I'm going to send that one, kick that one up to the department, let them make the decision, and knowing full well that I'm going to end up having to write a report on what is required and what isn't required. Okay, so again, SPQ, very important thing. And again, SPQ is not a statutory disclosure. It is a contractual disclosure. We're going to see that as you see right there, it is a very important disclosure. So here's ESD, agent's visual inspection disclosure, one of my favorite forms. And I'm going to show you a little trick in here. Let me take us to that form. I'm going to go back here really quick. No, I don't want it. And we're going to go to my avid. Remember what I said earlier? The TDS is considered not complete until the seller's agent provides their avid to the buyer. Okay. All right. So let's take a look in here. Here's my avid. Notice my revision date is 12/21. And this page 1, I've had so many court cases where they just put page 1 up on the board in 10-inch letters. This last paragraph, you need to read this paragraph. This paragraph is very, very important to you. It tells the buyer that your inspection doesn't substitute for their obligation to investigate the property. Okay. Then I get down top of page 2. I need to see this completed. I rarely ever see it completed. I want to know who else was there. Nobody cares until you get into court. And then it's like, well, who else was there? Well, why didn't you put that on the form, right? What are the weather conditions? You put in there sunny as a bell, always in San Diego. And then plaintiff's counsel looks up the weather that day and it was raining cats and dogs. Okay. So, it makes you look pretty stupid. All right. And maybe impeaches you as a witness. So here's my, based on a reasonably competent, diligent visual inspection. How many times? Reasonably and normally accessible areas of property. How many times am I going to see this before I realize how important it is? Okay. And so the page 2 is the interior of the property. Page 3 is the exterior of the property. And then just as a little heads up, this little box right here, the Department of Real Estate has said that they're going after teams. So it says right here, firm who performed the inspection, but then here is the signature of the licensee who performed the inspection. So what we're seeing is we're seeing an individual agent go do the inspection, take it into the office, and the team leader signs it. That's in the words of the Department of Real Estate. And listen, folks, I listen very carefully to when they say things. They think that's fraud. Fraud's a very bad 4-letter word, right? It's not 4 letters, it's a 5-letter, very bad. Okay. You intended to deceive someone. You didn't do the inspection, but you said that you did. And so watch out. This is important. Trust me, the Department of Real Estate has plenty to do, but they're on that right now. So it's a big deal. Okay, everybody good with that? That's my Avid. Let me see, how am I doing here? We are gonna run out of time. Okay, all right. So TDS is not considered complete until the seller's agent provides their completed Avid to the buyer. We talked about that. Appraisal discrimination addendum that's included on your contract now. That's going to be Civil Code 1102.6. So again, my TDS law was 1102.3. Okay, so the appraisal discrimination addendum, and I'm not going to keep pulling all these up, or we're never going to get out of here. What time is it? That is now an addendum to your purchase agreement. So if I actually look at my purchase agreement, let me see, do I have it up here? Where do I have it? I look at my California residential purchase agreement, and I see all the forms that were added to it. There's my agency disclosure. Oh, by the way, the realtor acknowledgement form. So I'm on standard forms. I'm sorry, I'm on professional standards at the state level. And in our meeting, we discussed requiring the realtor acknowledgement form to be added to this template. So you're going to, and my understanding in a meeting I was in last week was that they approved that at the board of directors. So you're going to see this. I've been telling you this since 06, right? So in 2006, we created the realtor acknowledgement form, and I'm going to show you that form in just a second. You're going to see that now added to your template. Okay. So here's my agency disclosure, my fair housing disclosure. So blah, 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 blah. There's my purchase agreement. I go flying past my purchase agreement down to the bottom. And here as I exit that, I got my buyer's investigation advisory. Remember, it used to say buyer's inspection advisory, but I've been lobbying for getting that changed to investigation, because that's the buyer's obligation, is to investigate. The agent's obligation is to inspect, but the buyer to investigate, right? Okay, you're buying a house, you're taking it seriously, right? So here's my Fair Appraisal Act addendum that I told you about a second ago. It is attached to your offer to purchase, and it essentially gives resources to the buyer if they have a complaint, feel like they were discriminated against based on any of the protected classes. Okay, and here's a short list. There's 17. I'm sorry, there are 22 protected classes in California, different than in other states, by the way. They obviously the Fed, but then you also have the state. So race, color, religion, including, religious dress, grooming practices, or both, gender. These are things that we can get into harm's way pretty easily if we don't understand, what our obligations are. So everybody understand that? That's my appraisal discrimination addendum. I have a final inspection report, and that essentially ties to 1102.6, and that's my fire hardening. Okay, so applies to property located in a very high fire hazard severity zone. My fire defensible space compliance, that's 1102.19. Properties located in a high or very high fire hazard severity zone. So we have introduced legislation now from the state level. This is where your political contributions come from, your RPAC contributions come from. So we have introduced legislation to require the natural hazard disclosure companies to do this report for us. Wouldn't that make everybody happy? I mean, how many of you have called me on the phone and said, I don't understand this fire hardening defensible space advisory form. Do I need to use it? Whatever. Now we're requiring the natural hazard companies to complete that form for us. Okay, that should make us all very happy. All right. So fire home hardening, again, 1102.6. Let me see, do I want to pull that form up? So for those of you who don't know what form I'm talking about, let's go to the again, I saved all this in a template, so it's easy for me to pull it up really quickly. So my fire hardening form, is going to be my statutory disclosure. And here it is right here. I actually kind of like the form. I hate to admit it, but here's the form. And again, I do a 2-hour class on the form, so I'm not going to be able to do that here now. But at the bottom of it, they actually have a worksheet, a defensible space decision tree. I really like this. I just wish that it was interactive. I wish that when you check this box, then it filled something in up at the top, but that's going to be a lot to do. Again, I think, like I said earlier, you won't even need this when the natural hazard companies change their format on what they're doing. So be aware that's coming. It should take place first of the year. Carbon monoxide detector disclosure, again, 1102.6. So TDS, right? 1102.3. So remember what I said earlier. I showed you the TDS and I showed you that the where did it go? Oh, I don't have it here. Okay, well, anyway, on the TDS on the bottom of page 2, you have your water heater and your water heater bracing and your smoke detector. You also have your carbon monoxide detector in here, so you don't have to make additional disclosures. So for those of you who keep sending me the form, we're just going to tell you no. Okay, let's see. It's included on page 2 of the current TDS. You have to be using the current version of the TDS. I don't know why you would use an old one. We do transactions all the time, and we have, we get a TDS that was from 5 years ago. Well, there have been changes to the TDS. Even most recently, there was a change to the TDS. So need to make sure we get that all in place. Here's my smoke detector statement of compliance. Again, by the way, we don't have necessarily these forms on the rental side of things, leases and that kind of thing. So we actually have to make the second, we have to actually use the forms. That's why we still have them in the library. So included on page 2 of the current TDS, water heater bracing, we talked about that. Same thing. I pulled up all the civil codes for you so you can look them all up. Again, current TDS. Water conserving fixtures compliance, that's going to be 1101, not a point of sale requirement. San Diego, by the way, doesn't require the water conservation certificate anymore because they feel like they have completed, that we've pretty much got all the properties by now. Again, it only applies to real property built on or before January 1 of 1994. So sometimes we're just using forms because we were told to use the forms. Window security bars, 1102, it's on the TDS. It's also on the MHTDS. Homeowner's Guide to Earthquake Safety. Again, that's going to be those environmental hazards booklets. So here's the laws that regard these things. There is no NHD form at CAR. Interestingly enough, so I asked Gov Hutchinson as chair of risk management. I said, how come we don't have a natural hazard disclosure statement anymore in the library? And so his response was a good one because the CAR form wasn't being used. Right, so that's an interesting statement. So it's the same reason, by the way, that we no longer have the contracts put in 5 different languages. Right, we don't have that anymore because we had the people weren't using them. So I had somebody send me an email a couple of days ago, said, where can I find that Spanish version of the purchase agreement? And the answer was no, you're not going to find it. So because we just don't do it anymore. Why? Because nobody was using it. So let's take a look. I'm just going to show you an example, and thank you to this natural hazard disclosure company that sent me this. But again, here's what was in our library, and that is a natural hazard disclosure. And so it tells me what zones, if any, the property is in. So here's my, and this is a fairly current report, right? So November of last year. So I would obviously update this one, but verify higher hazard severity zone. Yes, it's in it. Based on local jurisdictions, now they're looking this up. AB 38 disclosure form is voluntary. Okay, so they good, they have the parentheses in place and everything, and so the seller signs it, the seller's agent signs it, and then and then of course the disclosure that this was put together by a third party, and then the buyer signs it. Okay, there's no place for the buyer's agent to sign it because the buyer's agent's obligation is only to provide the form. So essentially you're relaying the form over to the buyers after it's been signed by everybody. Okay, and then without going through all of this, we'll have, again, in this particular report, the environmental hazards is in there. It's down closer. I thought I did this in a bookmark. Did I? I was pretty sure I did bookmarks for this one, but now I don't remember. So that I could take you to it right away. Edit. Nope, I'm going to end up spending more time on this than it's going to deserve. So anyway, the environmental hazards booklet signature is in this document as well. I'm almost inclined to try to find it. Let's see, where would it be? I gotta figure out my bookmarks. I don't remember how to do that. I apologize for that, but it would be fun, right? Wouldn't it, if I could actually show you that part of the document? So let's do environmental. And it looks things up. Here's my environmental report, hazards summary. I'm just looking for the form. Tends to be down at the bottom, of course. Pretty good report. I actually like reading these. They're interesting reading. I think well, now I feel like I'm wasting everybody's time. So let's get out of that. I'm gonna exit that. Okay. So that being said, let me go back over to the again, the form was not being used. So double check that the NHD company that you use is providing the following disclosures: mining operations, seismic hazard zone. I remember that we had a very large natural hazard disclosure company come in complaining about another one, saying that they are over disclosing, they're raising the bar. The fact of the matter is, I think that company didn't want to have to do more work that the other company was just doing by default. And so I thought it was an interesting complaint to have. And so I decided at that point that I was going to stick with the one I was using because they were the one they were complaining about. And so I was like, I always believe that whoever's complaining about it, that might tell me that's a good thing to do. So remember, in the NHD, the law in California requires the seller disclose that whether or not the property is located in one of 6 zones designated by the state of California to be hazardous zones. So 2 earthquake, 2 fire, 2 flood. So here's my special flood hazard area. So I have to make that disclosure. That's the law in California. And here again, I'm quoting all the civil codes and stuff, state responsibility areas, very high fire hazard severity zones. Airport in the vicinity is a requirement as well. Not all of the companies make that disclosure. It's not one of the 6 required disclosures. So those companies think that maybe they don't need to do it, which means you're going to have to figure out a way to do it on your own. Okay, so that's why I say be careful about the company that you use. Areas of potential flooding. There is a CAR form for tenants, by the way, called the tenant flood hazard disclosure, and that's going to be the CAR form. And again, because it's required in rental properties. So let's just take a look at that one really quick. Let's see if I can find it quickly. Tenant flood hazard. Where did it go here? There it is, tenant flood hazard. And up pops my form, and here it is. So this is your tenant flood hazard. I like this form. In our office, we're going to check the box that says it's in the zone. And why do we do that? Because if I tell them it's in the zone and it's not, they probably can't sue me for that. But if I tell them it's not in the zone and it is, then I'm subject to lawsuit. So I think CAR needs to redo this part. I think that the property is not located as the default. I would hate to find out that it was, because the default language says it isn't. So I would probably change that to say it is in the zone unless this box is checked, which says it's not in the zone. You follow me there? So I think they should probably do that, but that's my personal feeling. And again, I don't give legal advice, but we're working on plenty of stuff over there. So that's my. So we don't have an earthquake fault zone. Again, these are all. We don't have forms for these things. That's why we usually defer to the natural hazard disclosure company. Make sure your disclosure companies are making these disclosures. Let's see. They're actually there's no notice form, although we do have an advisory. Common interest development documents, obviously, advisability of title insurance. There is no law in California that requires title insurance in a real estate transaction, right? Who requires it? Well, usually the lender requires it, but there's no law. And so, unfortunately, the courts have held that it's easy to obtain, it's readily available, it's good business practice. Those are bad things for us as real estate agents. For the real estate agent that advises the client not to get title insurance because they're paying cash, for example, There's nobody to tell the buyer that they should have title insurance. And I've had cases, really bad cases, where the half brother sold their property to the other half brother. They were both on title, and one for consideration for money gives up his interest in the property, and then the remaining owner finds out later on that there were IRS tax liens that exceeded the value of the property. So no title insurance, therefore no indemnification from that. So there is no law in California that requires a pest control inspection report and certification. Okay. However, that's called wood destroying pests or organisms. There's no such thing as a termite report. Okay. And I've had attorneys call me up and say, we didn't get a termite report. I said, you mean a wood destroying organism report? They go, yes, you're right. I'm sorry. So, there's just no such thing as a termite report, but we call it that. Why? Because we can't say 4 letters. I mean, 4 words. So it's Civil Code 1099. And that Civil Code says that if there is a report, you must deliver it and the subsequent certification of the work completed to the buyer, if there is a report. Now, I'm going to tell you something. Plaintiff's counsel is in every real estate transaction. The buyer closes the deal. They go in, they're looking at the water heater. They see a sticker on the water heater that says it was inspected, but they never got a copy of the report. Or worse yet, there are 4 different or 5 different reports. So plaintiff's counsel for sure is going to go up online to the California Structural Pest Control Board. It's a whole department, right? It's a whole department. So you can go there, you can look up the property, you can find out whether or not. I assure you, plaintiff's counsel is going to do it. So if your seller says, I don't have a report, and you might make that a practice, because the seller is going to give the buyer the report that says, I don't know what termites look like. I don't know what wood destroying organisms are. I don't know what the fungus among us is. I don't know what those things are. And so, they got that report because that has a zero sum for what the work they got to do. And so that creates a problem for us. So we may have an obligation to go look that up. I don't think we do, because it's like pulling up a permit, right? We don't have an obligation to do that. But if you suspect that something is wrong, or you have reason to believe, then you might want to be adding that to your quiver of arrows. So only if required by contract or the buyer's lender. And so that's why we don't put that language in the contract anymore, because in most cases it's not required. Okay. All right. So again, take a look at paragraph 12B1C, which is the paragraph in the purchase agreement that essentially tells the buyer you have the right to investigate the property for these things. And so it's the buyer's investigation, not the seller. We don't want the seller investigating their own property. Okay. All right. Okay. That being said, moving right along, private transfer fees, those are required. We don't have a form for that. Okay. Civil Code 1102.6 again. Notice or actual knowledge of release of illegal controlled substance. Were you aware of a release? If you weren't aware of it, then you can't really disclose it, right? But a methamphetamine contamination notice is a recorded document. So I would advise that your title company should be picking that up. Okay. But again, that's going to be whoever's choice of title. I think it's really important. I see the battle constantly between real estate agents on the escrow company, the title company, the natural hazard disclosure company. I had a case a while back where the seller's agent insisted on a particular natural hazard disclosure company, and they made a mistake. And guess what? The seller said, I just did what he told me to do, right? And so the agent went for that. That's called a negligent referral. So you don't want that to happen in your real estate transaction. Everybody good with that? Again, this is health and safety code. And then we have a form, the methamphetamine contamination notice. I'm not going to pull it up. We don't have time for all that, but flood disaster insurance requirements, again, 42 U.S. Code 5154. Groundwater basin. I mean, I imagine most of us never realized there were all these statutory disclosures in a real estate transaction. Okay, so if received, okay, that's Code of Civil Procedure 836. Supplemental property tax notice. Now, most of us got in the back of our head, we're thinking, I know what that is, right? Well, you're going to find it's 1102.6, but you're also going to find that it's included in the SBSA. So I don't know why you wouldn't if you did a real estate transaction, I don't know why you wouldn't use the the SBSA. I think the SBSA form is a great form. I really do. It kind of came out indirectly from San Diego, but essentially, you know, like our local area disclosures, they just started adding stuff to it. So it's a pretty extensive form today. But in that form, and the supplemental property tax notice, just for your information, is going to be, you know, when the a property transaction closes, the county has to, well, the county, they don't have to, they will reassess the property based on the value, they call an ad valorem tax, based on the value that the buyer paid for the property. Well, that's almost always different than how much the seller paid for the property when they bought it back years earlier, right? And so that's going to trigger a supplemental property tax notice. So why is that? Because the property taxes are going to be prorated at the time of the transaction, right? They're going to be prorated at the time of sale. And so because of that, where'd Linda go? They're prorated at the time of sale. Well, the county doesn't know how much the buyer's tax is going to be until they get the notice of how much the sale was, et cetera, et cetera, et cetera. And then they recalculate everything. And then they give you this bill, this interim bill for the period of time from the closing until they give you the bill. And then all future tax bills will be just normal tax bills. Well, that supplemental property tax notice you will see always on your title report, right? It's always going to be there. And have people tried to dodge it? Well, yeah, you buy the property and you don't pay it, or you buy the property and you sell it again right away before anybody finds out that there is one. And these are exceptions to title. These are things, and this is why you want to be really careful that there's a good title company involved in the transaction. So again, supplemental property tax notice, it's covering that gap between the sale and then the actual tax that's going to be required of the new owner of the property. Okay, so we have a form, supplemental property tax form. No need for you to use it. The disclosure's already been done in the statewide buyer and seller advisory that you had your client sign. Some of you remember in the old days, we actually had a place to initial at the bottom of each page. And today they've eliminated that because it's an advisory. So, you know, you have a signature page at the end. But we do have a form called the SPT. But again, if you use the SBSA, you don't need it. Okay, all right. Gas and hazardous liquid transmission pipeline notice. Now, you don't think this is a big deal. This created a lot of discussion at SDR's risk management committee. You know, there is literally an 8-foot tube running down underneath Rosecrans in Point Loma, full of gas. And so we argued about, you know, about whether or not we should be telling the world essentially where all our gas pipelines are, because we were worried about terrorist activities and things like that. But we lost the argument. The legislative body came back and said, no, we want you to make the disclosure. So, okay, I get it. Do I get nervous whenever I drive down Rosecrans? Not necessarily, but listen, if that pipe's going to go up, then it's not going to matter what I'm doing at the time. Okay, Jillian, yes, absolutely. SPT is also included in some of the NHD reports. Very good. Okay. Included in so again, my gas and hazardous liquid transmission pipeline notice is included in our SBSA form. Okay, meth lab cleanup order. You know, it was interesting. I was working with a bank and we were buying properties all over the country, and I remember that they went into a house in New York in the Bronx that you know, they were buying 400 homes a month. And so they had their people go into the house, the front door was gone. They go into the house, there's an open flame in the kitchen, and then somebody smelled meth, right? Well, meth is incredibly caustic, it highly explosive. And so they backed out of the property. You know, needless to say, they didn't buy that one. But you know, people don't necessarily have their head about them when they're on meth. And so when meth contaminates a property, it gets into the ground, it gets into the features of the property, and it's a very complicated process in cleaning it up. It's not something where you just grab the Clorox and wipe it down, right? It's much more complicated than that. So you know, if you see a methamphetamine contamination notice, an MCN, you know, this is going to be health and safety code. I'm not going to tell you not to buy the property, but I'm going to tell you need to make sure you make all the disclosures to everybody. May make a great deal, right? But I know we were looking at properties in the Midwest that that we were going out to the properties and we were seeing these places, and it was very clear that they hadn't been foreclosed on yet, because there were meth labs being operated in the house, and they weren't in foreclosure. They were in the process, but the banks had not foreclosed, and the banks made the decision not to foreclose on the properties because the cleanup would have been more expensive than the debt service on the property. So they just chose not to foreclose. I don't blame them for that. Question. Could be all the way to the studs. Oh, yeah, clearly, Zeno. Yeah, in this, listen, this is ugly stuff. And it goes boom, right? So, it goes boom long after this is over with. So, definitely bad news. Release of illegal controlled substance remediation orders, things like that would be a matter of record. Death on the property in the last 3 years, again, Civil Code 1710. We're in the statutory disclosures, not even in the contractual ones. So death on the property, you must by law disclose the death on the property in the last 3 years. So, we've had transactions where the only disclosure was put in the ESD. Well, at least they put it in the ESD, right? Death on the property. So, do you have to make fanfare out of it? It's interesting. I get the question, from people, we've got the property in the multiple listing service. Should we disclose the death on the property in the multiple listing service? And so, first of all, you don't put it in the regular remarks section. If you're going to put it in there, you put it in the confidential remarks section. But remember, that's not going to constitute a disclosure to the buyer. You're just telling the agent so the agent can warn their buyer ahead of time that the condition exists, right? And again, the buyer doesn't get access to the agent printout and shouldn't get access to it. Our rules say no. So how do you make sure you draw the attention to the buyer of the fact that there was a death on the property? And again, you have the forms that I think you need to be discussing those with the buyer. Okay, so death on the property for sure. Megan's Law's disclosure. Again, our requirement is by Civil Code 2079. We have an obligation by law to disclose only the existence of the database. We do not go to the database. Very common misunderstanding. There is no obligation. I have never been to the database, okay? And I'm not going there. And I tell people all the time, don't go to the database. And they say, why not? Well, because you can be held to have constructive knowledge of everyone who's in the database. So buyer buys the home, and I can tell you what the depositions look like. I'm in depositions all the time. And the attorney says, why didn't you disclose the registered sex offender next door? And the agent says, I didn't know there was a registered sex offender next door. And then the attorney says, well, when's the last time you went to the database? And the agent says, well, I went there, last time I went there was about 6 months ago. And then the attorney says, they were on the database 6 months ago. Why didn't you disclose the death of the buyer? I'm sorry, why didn't you disclose? Sorry, I had something pop up on my screen. Why didn't you disclose that the neighbor was on the registered sex offender database? It's like, well, I didn't know. Well, how do we know you didn't know? You said you were at the database. They were on the database at that time. We think you saw that, but didn't tell the buyer. Okay, because it's the buyer that sues usually on this, right? That's a bad case. Okay, I'm telling you, I wouldn't want that. Do you have to disclose that the seller's on the registered sex offender database? I think logic dictates that you don't, unless the seller is staying in the property after closing, right? My little sister bought a house in San Diego on Cali Way, and she calls me up and she says, you know what? The neighbor, the two guys living next door are both on the registered sex offender database. My sister looks up stuff like that. And I go, really? And she goes, yep. And I said, well, what do you want to do about it? Middle of the transaction, right? What do you want to do about it? She says, well, we've got 3 dogs. I mean, we don't have any kids. And I said, yeah, but it may stigmatize the property. I mean, I don't know. People are everywhere. Okay, so she bought the property anyway. She said, "What are they going to do to the dogs?" But but they moved out a month later. I mean, the two of them left, and so now they are no longer next door neighbors. But how do you know that 2 doors up, 3 doors, 4 doors, that could be in proximity of the property? They don't have to be next door neighbors. So my advice: don't go to the database. By the way, if you are on the database, it is against the law for you to go to the database. Isn't that an interesting concept? The penalty is $1,000. So what are you going there for? To look see if your picture's right or current or whatever. You shouldn't be going to. You didn't get on the database without knowing about it. You were convicted of a crime. So again, make sure you emphasize to your client that they should satisfy themselves. They should go to the database. You do not have an obligation to go to the database. I would not be going to the database. Okay. All right. It's included in CR form paragraph number 11, RPA 11. Criminal penalties to go to the database if you are on the database. Notice of special tax and or assessments, Melrose, Civil Code 1102.6. So remember, when does the Melrose disclosure, Jillian, you know this better than anybody. When does the Melrose disclosure occur? Almost always at the time that the natural hazard disclosure occurs, right? Because why? Because the seller doesn't know they need to make that disclosure, but again, they have a right to rescind the contract before, until you give them that disclosure. So, my advice, you take a listing, you get the natural hazard disclosure ordered right away. We order it immediately. We order the natural hazard disclosure right away, and it's going to include whether or not there's a Melrose, at least with the companies that we use. So check with the company that you use, but we make that disclosure. We make sure that when the buyer brings in the offer, we send all of the statutory disclosures. This is a very important point. We send all the statutory disclosures over to the buyer along with the contract, okay, with the counteroffer. Had a transaction up in Lake Forest where I sat down with the seller for 3.5 hours at the time we took the listing, got everything signed, HOA information, and NHD was done, the TDS, SPQ, everything. Both statutory and contractual disclosures. Okay, buyer comes in, we send over a counter offer that includes all of the disclosures, and the agent says, "Oh my God, it's like 88 pages." I go, "Yeah, well, we have a lot to tell you about." But you understand that your buyer, when they sign the contract, they're aware of all of these things, right? And so they may not have a right to rescind. I can't tell them they don't have a right because I'm not an attorney, but they may not have a right to rescind the contract based on the information that we've disclosed to them. And the buyer came back. And the buyer said, "You know what? This is great. We were going to do a 30-day escrow, waiting around for you to send us all those disclosures. You gave us everything up front. So we're just going to go ahead and close it." We closed it in 13 days. I mean, it was a 2-week, I'm buying a boat, I got all kinds, right? So we made all the disclosures at the time of contract, the buyer. And again, if you look at the bottom of page 3 of your TDS, you'll see that language is in there that says that if those disclosures are made prior to the buyer committing the contract, and I grabbed the wrong one, gosh darn it. Where did I put it? Here. Okay, so I'm going to go back over to my NHD. Okay, sorry. 6 o'clock. I lost my train of thought. I'm sorry. I had something going on in the background here. Let me go back to my screen. Melrose. All right, I lost it. Sorry, I lost what I was talking about. Okay, so here's all these codes that apply to it. Oh yeah, TDS, duh. 12 years of college down the tubes. So let's take a look at my TDS real quick here. Again, like I said before, one of my favorite documents. I'm going to close that window. I'm going to take you down to the bottom of page 3. And at the bottom of page 3, it says 1102.3, Civil Code provides a buyer with a right to rescind a purchase contract for at least 3 days after delivery of this disclosure if delivery occurs after the signing of the offer to purchase. So if you send it over with the offer to purchase, they knew what they were buying. The courts say, you knew what you were buying. So you know what? You don't have a right to rescind the contract. I love that. Okay, that's my job in being thorough. Okay, if the seller has actual knowledge of industrial use and military ordnance, notice there's no I in ordnance. That means stuff that goes boom. So like Coronado, the Strand, right? The Tierra Santa, things like that. So you have to make that if you're aware of it. And fortunately, hopefully, you're using the NHD platforms that contain those. So contractual disclosures, we're not going to spend a whole lot of time on that, but because because, those are the things that don't have rescission rights. Now, what they do have is they have cancellation rights. And that's very different than a rescission right. Rescission right, remember, puts everybody back in the position they were in prior to contract. Cancellation right says might have the way to get out of the transaction, maybe an opportunity for the parties to exit the contract without penalty. Okay, maybe. You are not in a position to make that decision. So if the buyer says to you, I want to get out of the deal, you don't say, well, here, let me help you, or here, let's do this. No, they need to talk to counsel. Okay, and it's so funny how many times I get this where people say, oh, well, they can get out of contract for any reason for 17 days. That is not true. Okay, do not ever tell anybody that, right? That's legal advice. Okay, and then you're trying to help them. That's going to be called interference with contract. That's a tort. You go for that. I mean, it's going to be a very bad day. Okay, so remember, statutory disclosures include rescission rights. Contractual disclosures contain cancellation rights. I wrote that again. The RA form, I love the RA form. we're not gonna have time to pull that up here, but the RA form, I think, is the very first form you ever sign in front of them. Give them a copy. It explains the difference between a realtor and a licensee. And the Department of Real Estate, it's Business and Professions Code 10177. If you call yourself a realtor and you aren't, in other words, you're a licensee. So we have 435,000 licensees in the state of California. Less than 200,000 of them are realtors. Okay, so half, right? Less than half. And so you tell somebody you're a realtor when you aren't, you can lose your license. It's pretty clear. Lose your license. If you don't have a license, you can't even get a job in a building that has a real estate company in it. You can't even, not even as a janitor. Okay, so it's a big, big deal. I love the form. Been using it, part of our template. Seller property questionnaire. Again, very much like my TDS. So we have my TDS. That's a statutory disclosure, but we know that the TDS was not necessarily as comprehensive as it needs to be. So standard of practice, standard of care in California, I'm going to use the SPQ, okay? Seller's affidavit. These are, there's no requirement for you to do a FERPTA, right? The problem is that if you don't do one, then the buyer may have to withhold a portion of the proceeds. So it's going to be 3 1/3% of the sales price, or 9 1/3% of the profit on the transaction. They're required by law to withhold that, or else they have to pay the tax. So we want to be careful that we're in that food chain as well. So there's also the qualified substitute form. Most of your escrow companies have gotten, I mean, we had a fight with escrow when they first came out to try to get them to do these. Some of the escrow companies refuse to do it, but you need it in your file. Okay, talk to your broker about that. Again, California Revenue and Taxation Code. SDR's got some great forms. The seller property questionnaire addendum, I love it. So where the TDS fell down and the SPQ didn't quite cover everything applicable to San Diego, we got the SPQA form. Use the form. We have the addendum to purchase agreement. The only form I'm aware of in California that gives you the ability to disclose your license status or your what we call familial relationship with one of the parties in the transaction. Okay, and then you got your warnings. You got your cyber crimes advisory, your wire fraud advisory, your local area disclosures, your SBSA, your market conditions, your water conserving plumbing, your environmental hazards, parking and storage. I do statewide buyer and seller twice. I sure did. Look at that. I'll be darned. So anyway, it looks like I'm going to get you out of here a couple of minutes early. I do want to thank you for joining us for this. Do you have any questions? Please, this is a good time to ask. I'm putting all of this up on the YouTube. This will go up tonight. The one from this morning, Master My Farm. This one will all go up this evening. I've got a QR code. I learned how to create QR codes just so that people can get to it faster. Here's the QR code. Take a picture of that, or you can go to at Burke Real Estate Consultants Inc. And again, notice the case. That will take you straight to the webinars. Here's the bit.ly link. I'm required, the Department of Real Estate is required, because I've been approved to teach the RPA for 5 hours of CE credit. I've been approved to teach the buyer representation agreement. I think that's 3 hours of CE credit. So I have to put the general information page up on our website for everybody to see prior to deciding whether or not they want to sign up for the class. So be aware. I think those are going to be fun classes. I'm very excited about those. But they will be on the website when we're ready to start teaching them. Case is important. Please remember to like and subscribe. Again, like just because it makes me feel good. I don't get brownies for it or anything. But subscribe because that way when I update the videos, when you log into YouTube, you'll get notice that I've updated the videos. Okay, so it's for your benefit. All right. Again, remember we're going to be doing podcasts. That's where we're heading in our company. We're heading to podcasts to help people understand. I can tell you I've had calls from members of the public who are seeing my YouTube videos. I'm uncomfortable with that. I know that plaintiffs' counsel, I'm usually the defense expert, so I know that the attorneys are going to my webinars looking to see if I've given them inconsistent information in a deposition. I assure you not. So be aware of that. We'll start doing the podcast. We're going to have to create a firewall for it, but they're going to be some pretty good ones. I'm very excited about the opportunity to do that. And they won't be 2 hours. They'll be snippets of things, which will make it easier for you to just go in and get what you want rather than, the indexing is going to be important rather than everything. Okay, everybody good with that? If you're not getting the newsletter, then you're probably not going to know where we are. And that's going to be coming in the next couple of months. So I recommend that you get the newsletter just so you know where is Waldo, where is Kevin, right? So my advice, get it. And that's kind of where we are. So again, I don't put people on it unless they ask me put on it. But I do want to thank you for being here today. I very much appreciate the value of your time. I don't want to take more of it than I need. If you have any questions, please send me an email. I am happy to help you in any way that I can. And again, I very much appreciate you. I will not be back until next week. Thursday, I'm speaking at NAREB up in Oakland on Thursday and Friday, so I won't be able to do our classes. But again, I thank you very much. Zeno, thank you always. I so appreciate you. I'll have to ask my daughter how to get on podcast. Zeno, that's funny you say that. I'm in the same boat. I didn't know what they were, right? Now, the DRE has asked me to do some podcasts for them. I'm pretty excited about that also. And then I decided, wow, that's the way it's going to go. Thank you, Jillian. That's the way it's going to go. So you know what? I'm in because I want to deliver value, rather than being repetitive in some of these webinars. So I want to catch you with what you got to have. So thank you all for being here. I very much appreciate you. I wish you the very best this coming week. And if there's anything I can do to help you, I hope that you will let me know. Take care for now. Bye-bye.